Hello, I'm Natasha, a videographer in Buenos Aires. I'm here with James Billings, founder of Trust Heart. We are here to ask him a few questions about Trust Heart, to know a little bit about different types of trust and a little bit about the history. Pour ceux qui parlent en français, nous aurons une traduction de cette vidéo par écrit. Para los que hablan en español, tendremos una traducción escrita de ese video. So, James, could you explain the viewers a few other examples about trust so that people can understand what you are doing?
Well, here's a couple of everyday examples. Let's just put all the estate stuff and the business stuff aside for the moment. Okay, you have children. Okay, so you want to go out one night and you want a babysitter to take care of the kids. Okay, so now you're trusting the babysitter to take care of your kids for you. So you're the person that's creating the trust. The babysitter is the trustee. And then the kids are like the beneficiaries. I mean, you are a beneficiary as well because they're caring for your children. We also have pension funds. That's kind of a business setting. You know, when you have a regular job and you pay into a pension fund, you're trusting that people, that contribution you make to that pension fund are going to invest it and there's going to be more money tomorrow. Because that's another example of a trust relationship. You know, if you're looking for a real estate broker to find a house for you, you're trusting, you have some confidence in the person that they'll find you a house to buy, and you're the ultimate person that benefits from it. Yes, there's some money involved in it, but the point again is that you've got this relationship with another person that's going to help you or do something for you or execute upon your wishes, your desires.
And what is the origin of this trust?
What I like to go to is to the Roman times. It's about 2,000 years ago, and the Roman elite, the senators, the people with money in Rome, of course you have to remember that there was not much written at that time because people were not literate. They had a relationship, and then they called it the fideicommissa, which they have in other countries as well as a part of civil law. I think that's what it is. And so what happened originally was that the fideicommissa was to circumvent Roman laws on inheritance because if you were not a citizen of Rome, you could not inherit property. And mostly property was about real estate. You had to be a citizen of Rome in order to inherit property according to the rules of Rome. So they created the fideicommissa to circumvent those because I want my property to go to my nephew. And so that was the only way that they could circumvent the Roman laws on inheritance. So the fideicommissa was one of the first examples of this trust relationship. But the Romans did not use the word trust. Trust came about from the Middle Ages in the UK, or it's not UK, it was England, I guess was the term they used at that time. Henry VIII in the Middle Ages is when the word trust really became used, and that had to do with real estate. Because one of the things that happened in that particular time is that you had obligations to the crown if you did not fulfill them, whether it was military service or if you said something wrong about the crown, they could claim that it was treason and take your land. If a father died and there was only a son, the crown could take the land, or there were fees that would have to be paid to the crown in order for the son. The crown became the ward of the son. And so there was all kinds of ways that in the feudal society that the small landowners could lose their land to the crown. And so Henry VIII, this was kind of going on at that time. So what happened is that the landowners went to the dukes, who were the only powerful offset from the king, in order to become trustees, to hold the title to the land. And there was multiple trustees, so it wasn't just one. In case one of them died, then they would lose it, and again, we're at risk to the crown. Anyhow, so the dukes were the offset power to the king, and this was one of the popular things that happened during the time of Henry VIII. And they also had what was called the Statute of Uses. And uses is not exactly the way we use the word use today, but this is how they did it many, many years ago. And so we had to have things in writing. There was no more verbal stuff. And one of the things that came out of all this is that we had what was called the court of equity, because you have legal title to the property, but if somebody loans you money on behalf of the property, they do not get legal title to the property, but they do have rights in the case that you don't repay them. And so this is the beginnings of the court of equity, which now, many, many years later, that's all sort of rolled into one with the, there's some exceptions to it. So the Romans, the fideicommissa for the estate planning, if you will, trust, we want to make certain that our kids get our stuff. Then you have it, many, many years later, you have it in the Middle Ages. The same kind of situation. We want our kids to get our stuff. At the same time, we want to be safe and protected. So we had to engage, some other people to be the trustees that we trusted in order to make certain that everything passed according to our wishes. There was also legacies. I mean, this was one thing that the Romans had, that they wanted to have like a statue erected to them. And so that would be part of like a legacy that could be part of the fideicommissa, because sometimes it was more than just land or some precious stones, what have you. They wanted to have a memorial, built to someone that was powerful and was influential in society. And then with the living trust, how it all got started, and then what happened was that the United States, as a part of our constitutional law, we adopted English common law into the United States. And so although, we've evolved since that period of time, that's kind of our foundation that we have in the United States, is the English common law, which actually is in other countries as well. You have it in India, in Australia, in New Zealand. I think Singapore also has it. Canada. Of course, what I'm talking about here is mostly the common law and the laws that we have in the United States, because the people that I deal with mostly are interested in business in the United States. If we're looking about, the business trust, if you will, foreign investors are looking for stuff that we have in the United States. But then for the living trust, for people that, want to have an estate plan, those are United States-based people as well. I've studied at the Vatican Library. I've looked at some of the origins. I've been to the American Academy in Rome, to research all this and look at some of the old texts, see how all this evolved. It was really fascinating to me, in addition to just this title aspect of it. Well, how did all this stuff start? And it all started with a sense of security and safety and somewhat privacy. So it's not just a new thing because of the internet. This has been around for a long, long time.
Well, thank you very much for answering all our questions. And if you have any other doubts or any question, you can visit the TrustHeart website, and see you in the next video.
All right, thank you.
Bye.